May it please the court, my name is Stitt, initial MJ, and I'm instructed by Mathers & Co lawyers, and I appear on behalf of the applicant, Ms. Kylie Truman. This is an application for the interim orders numbered 1 to 2 on the initiating application by Ms. Truman. And I'm seeking leave to read and rely upon the affidavit of Ms. Kylie Truman, affirmed on 19 September 2019, and the applicant's financial statement summary, which I tender. Your Honour, before we commence with the background of the matter, the applicant wishes to raise 2 objections in relation to the respondent's affidavit sworn 19 September 2019. The first objection is in relation to paragraph 5 of the respondent's affidavit, particularly where he states, "The applicant is not any good with money, and if she gets her hands on any of my winnings, I fear that she will spend it on things she doesn't need." Your Honour, it's the applicant's submission that that statement is a matter of opinion and is therefore not admissible. It's our submission that the opinion is one that cannot be validated, and it's not one that the respondent is qualified to give. We further object to paragraph 6 of the respondent's affidavit on the basis that it's not relevant. By way of background, the applicant and the respondent were in a de facto relationship and were living together in a rented apartment in Queensland for the past 10 years. The applicant has not worked in paid employment for the last 5 years, as she manages the home, takes care of household affairs, and volunteers at a local church for approximately 8 hours a week. The respondent works as a boilermaker in a large engineering company. The applicant and the respondent have a joint savings account containing approximately $30,000, a joint cheque account, and a joint credit card which they both have access to. If I could now turn to the events which are at the centre of the application and take Your Honour to paragraph 7 of the affidavit of the applicant explains that the respondent has been part of a lotto syndicate called Us Boys for the past 3 years. The syndicate was made up of the respondent and 10 of his work colleagues, and the applicant was aware of the syndicate and was aware that they'd had small winnings from time to time. However, the applicant herself was not a member of the syndicate, and it's not clear exactly where the funds that the respondent used to put in for the purchase of the lotto tickets was coming from. The applicant seeks to rely on 2 cases in this application. The first is the matter of Zeke and Zeke, 1995, Family Court of Australia 135. The facts of that case were the husband was part of a lotto syndicate since the 1970s. The syndicate won a major prize in 1987, and the husband received $94,907 as his share of the winnings. The lottery tickets were purchased by the husband from his own money, and the proceeds from the winnings were handed to the wife, who then applied it so that it therefore formed part of their joint property. The court in this case found that the preferred approach was to consider the winnings as a contribution rather than a windfall. However, the court made it very clear that the specific facts of each case should be taken into account when deciding which approach to take. In this case, in paragraph 50, the court found that where the parties were both in receipt of income and the marriage was predicted upon the basis of each contributing their income towards that partnership, the purchase of a ticket should therefore be regarded as a purchase from joint funds in the same way as any other purchase within that context would be. The court further went on to say that this also applies where one party is working and one party is not, which is a similar situation to the case we have here. This is because that is the mode of partnership selected by the parties. The income of the working member is treated as joint in the same way as the domestic activities of the non-working partner are regarded as being for their joint benefit. The second case that the applicant seeks to rely upon is a matter of Anastasio, 1981, Family Law Courts 912093. The facts of that case were that the parties were still married and living together at the time the husband came into possession of the $60,000. The money used to purchase the ticket came from the husband's earnings, and like the case you have before you today, Your Honour, the parties in Anastasio were wanting to buy a house together. The inference was drawn by the courts in that case that the purchase of the lottery ticket was an example of the parties attempting to acquire funds to enable them to do that. It was therefore held by the court that the winner of the lottery ticket should be regarded in the same light as any other asset acquired by the parties during the marriage and distributed between them in the same proportion and in the same manner as any other asset. Your Honour, it's our ultimate submission that an injunction should be granted pursuant to section 114 2A subsection C of the Family Law Act. It's our submission that the court has jurisdiction to grant an injunction as the matter relates to a de facto financial cause. It can be described as such in these proceedings, as these proceedings relate to property which was acquired throughout the course of the couple's de facto relationship, and now due to the breakdown of that relationship, they're required to be distributed between the parties. Paragraph 1 of the applicant's affidavit demonstrates that both herself and the respondent were in a de facto relationship and they'd been living together on a genuine domestic basis in a rented apartment in Queensland for the past 10 years. The winnings we submit were received in the course of their relationship, and that therefore that should mean the winnings constitute a part of the couple's joint financial property. Paragraph 9 of the applicant's affidavit describes how the applicant discovered the lotto winnings had been deposited into a separate bank account by the respondent while the couple was still living together. Paragraph 10 of the applicant's affidavit demonstrates that the couple then separated the morning after the applicant confronted the respondent about the money. We also submit that the court has jurisdiction to grant an injunction as the relationship length of time requirement of at least 2 years and the geographical requirements are met. Paragraph 1 of the applicant's affidavit demonstrates that herself and the respondent had been a couple and were living together for the past 10 years. The initiating application shows that they're not related, nor were they ever legally married. Therefore, the relationship length of time in our submission is satisfied under Section 90 SB of the Family Law Act. The initiating application also shows that both the applicant and the respondent are Australian citizens and that they live ordinarily in Australia. So that in our submission satisfies the geographical requirement under Section 90 SK of the Family Law Act. We further submit that an injunction should be granted as it is proper in the circumstances. The applicant has a reasonable claim for an order altering the property interest. And this, we submit, is due to her level of non-financial contributions which she made to the welfare of their relationship. Paragraphs 2, 4 and 5 of the applicant's affidavit explains the applicant's responsibilities she had of taking care of the household and managing their home in general. Paragraph 2 of the respondent's affidavit actually confirms what the applicant states in her affidavit in paragraphs 2, 4 and 5. We submit that the winnings should therefore be considered as joint financial property of both the applicant and the respondent. We submit that the applicant has a significant interest in the property and consequently has a reasonable claim for the order to alter the interest of the winnings. We also submit that if an injunction is not granted, there's a danger that a claim to alter the property interests under Section 90 SM may be defeated or prejudiced. We submit that there is a real risk of asset dissipation or a scheme to defeat judgment by asset dissipation in this case. The respondent has claimed in his own affidavit at paragraph 7 to having spent some of the winnings on a small plane and beginner flying lessons already. The respondent's financial statement summary shows that he has spent approximately $16,000 for the deposit of the plane and the flying lessons, which leaves approximately $384,000 remaining to date. We submit that if an injunction is not ordered, the respondent may continue to spend the rest of the money before the hearing for the final orders has even commenced. We submit that this will mean that the applicant will suffer a significant hardship, more significant than what she's already going to be suffering as a result of the separation due to her reliance on the joint account funds for the past 5 years. And as she's been out of the workforce for such a long period of time, we submit that her ability to gain paid employment again will be more challenging. We therefore submit that if an injunction is not granted, that it will therefore unfairly prejudice the applicant, as her interest in the winnings will be defeated due to the funds no longer being in existence, and her maintenance entitlements will therefore be diminished. It's our ultimate submission that the parties were in what appeared to be a stable and happy de facto relationship at the time the lottery ticket was purchased by the respondent. It's conceded that the respondent was the financial provider in the relationship. However, the applicant's household and domestic duties and contributions to the welfare of the relationship, we submit, are enough to satisfy the court that she has an interest in the winnings and that she has a reasonable claim to alter the interests of the property. This is consistent with the comments that were made in the matter of Zeke and Zeke, and it is our submission that it is just and equitable for the remaining funds to be deposited into that joint account and that an injunction be placed on the access to that account by the respondent in order to preserve what is left of the winnings so that it can be appropriately assessed and apportioned between the parties. Those are the submissions for the applicant. May it please the court.